nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Here. Robert Howard.
Here.
Steve Ballard.
Here.
Reagan Syson.
Here.
Lawrence III.
Here.
Denise Kinsler.
We have a quorum. We have minutes from April 14th. Any additions or corrections? We have a motion to approve.
Second.
Motion and a second. All in favor say aye.
Aye.
Motion approved. First item is case 6226, MB.
25 square feet. But the purpose of this request is to bring the property into compliance and to allow for the construction of a detached storage building using an existing concrete slab. The subject property is located in a single-family neighborhood and is adjacent to R3 and A1 zoning districts. Staff has found the requested actions are in agreement with the review criteria outlined in the Will County zoning ordinance. Both the Planning and Zoning Commission, as well as staff, recommend approval of the map amendment from A1 to R1 and the variance for maximum accessory building area from 1,800 square feet to 2,025 square feet.
Thank you. Any questions by committee? Any objectors to this change? We have a motion to approve the map amendment from A1 to R1.
So moved.
Second.
Motion and a second. All in favor say aye.
Aye.
Any opposed? Motion carries. We have a motion for the variance.
Motion.
Motion.
Second.
Second. All in favor say aye.
Aye.
Any opposed? Motion carries. Next case, 6227 SE2. Mike.
Thank you. Good morning, Chairman Weigel, members of the committee. This case takes place in DuPage Township. The applicant is requesting a special use permit for an outdoor storage yard. The variance for lot frontage from 80 feet to 60 feet, and the variance for fence height from 4 feet to 6 feet. Now, typically, this committee does not hear variance requests. Those two variances were denied by the Planning and Zoning Commission last week. The applicant has appealed the Planning and Zoning Commission's vote to the Land Use Committee. So in this case, you will be considering the special use and the two variances. The special use permit was also denied by the Planning and Zoning Commission last week. Staff recommends approval of the special use permit and variances. The Village of Bolingbrook and DuPage Township both object to the case. Now, these requests are to bring the property into compliance. The property's been in violation with the county since 2013. The property owner has been through the administrative adjudication process and the circuit court. In both cases, the property owner was found liable or guilty. This zoning request is to bring the property into compliance. As the property exists right now, it would be defined as a junk salvage yard. The special use permit request is for an outdoor storage yard. To achieve the definition of an outdoor storage yard, staff has recommended several conditions to the special use permit. One condition will require that all vehicles, including trailers, be licensed and registered. The second element to that is that all vehicles and trailers on the property must be operable. And that concludes staff's analysis.
Any questions by committee? Denise?
I have some. I did see the pictures of this particular yard, and it looks like a junkyard. I believe the applicant is saying that it's an antique parts yard or something to that effect. It's clear
The applicant utilizes the trailers on site to store antique car parts. So the trailers are filled with various car parts and other equipment. The applicant is here today. He could expound on that if necessary.
The rest of the stuff that is clearly not antique and is an eyesore. Besides giving the variance, what other options are there?
Well, if the committee and subsequently the county board were to deny the special use permit request and two variances, the owner of the property would have to remove everything.
Greg, can you give a comment?
Going on what Denise said, it's in the application. The issue I have is the application. I believe it to be disingenuous. It says that he stores or restores antique cars. Well, from the pictures and from my research and actually going to see the property myself, that's not what it is, and I have a big issue with that. If somebody's going to put in an application and says that's what it's being used for now, but it clearly is not. Secondly, what Mike had already said, that it's already been through the court system too, and they were found guilty and liable for that. And that was in 2013. We're in 2015. What has been done since then to rectify their findings of liable in those cases, if you know?
The circuit court, through a court order, ordered the property to be brought into compliance. There's really two ways you can bring a property into compliance. One is to abandon the use, or two would be to pursue the special use permit. Now that court proceeding was in the fall of 2014. So there was a year from the time the land use department first started working with the property owner to when it eventually made its way through the court system. And staff acknowledges that the current use right now is not an outdoor storage unit. What we've done is recommend some conditions that, if complied with, will bring the use so that it meets the definition of an outdoor storage unit. Of course, that'll take some work by land use. If everything's approved, our code enforcement staff will have to monitor the property and ensure that those conditions are complied with.
Okay, so Mike, you've worked closely with the applicant for this and spoken with him or his attorney regarding the agreement to all these different situations that he'd have to comply with if the
They have agreed with the conditions as written today.
Okay.
Yeah, the current zoning is industrial, correct?
That's correct. The current zoning is I-2.
Okay, and he's been there for 26 years?
He's been there for 26 years.
Okay, now when did this become an issue?
This became an issue in 2013.
Okay, so he's here for 26 years, and then approximately 2 years ago, we said this is an issue now.
And
Okay,
it's been an argument by the applicant that the use was grandfathered. Through land use department's work and research, we determined that the use is not grandfathered. It may have been established 26 years ago. 26 years is a long time for a use to be conducted on a property, but it did not meet the threshold required to be declared grandfathered or legal non-conforming.
and along those lines is basically when someone owns a piece of property, they utilize the property the way generally that they want to utilize the property. Then I think we have to be very careful, though, because at the same time, I'm a car collector and I collect antique tractors. I mean, you have to be very careful with what you deem as somebody else's collection. You deem it as junk. I mean, it's a fine line, I mean, and if you review your car magazines, anything like that, you're going to notice that basically they fight any kind of legislation against that because, some people, that's their passion, that's what they love to do, whatever. And in the meantime, some of us might cringe, some of us might, like what they do, that type of thing. So I think here to be respectful to a property owner, and if they're agreeing to meet the conditions, clean the place up, do whatever that, we're asking them to do, then I think we need to do that. And especially out in Eastern Will County, I mean, we currently have people interfering with other property owners' rights, whether it's the airport or the Ilian or anything like that. And at this point in time, I'm going to side with the property owner, and allow them the freedom to do that. As long as they're, the county's saying, hey, look, can you straighten this up? Can you do this? Can you do that? And they're saying, yeah, we'll go ahead and do it. So I think at this point in time, I think this would be a good example of property owners' rights. I think we have to be very, very, very careful on this because this could be expanded to other issues.
Don Moran, do you have a comment?
Thank you, Mr. Chairman, committee members. I drove by this property yesterday, and I go by it quite often. It's about a half a mile from my house. And this court decision was reached in the fall of 14, and I don't see any place that looks like they've started to clean this area up. So, there was a court decision reached in the fall of 14, and they haven't made any attempt, even though they applied for the zoning change to come into conformance. It doesn't appear that they've made any attempt to clean the property up what makes us think that they're gonna clean this property up if they get the zoning change? I think it's just a bigger nightmare for us going forward. I'd ask the committee to deny.
Thank you. The petitioner here, would you like to make any comments? Come down to the podium.
Good morning. My name is Mike Martin. I'm the attorney for the applicant. I'm at 15 West Jefferson, Juliet. Mr. James, the applicant, is up there. He's hard of hearing. I can guarantee he hasn't heard a word you said. Mr. James, maybe to help explain the car parts just a little bit, used to own Ed James Chevrolet. He's an avid car collector. The property was actually zoned 36 years ago in 1979 to I-2. He didn't put it to use until 1989. And that's when he started putting the trailers on it. The court decision was it wasn't grandfathered because we didn't put the slats in the fence to screen it until 2013, when there was a complaint by the mayor of Bolingbrook that the property was a mess. We did clean up debris piles from the property. We did put the slats in the fence following that complaint, and he took his legal right to argue that I'm already zoned, I don't have to go through this process. He lost that, so now he's a honorable citizen. He's coming forward. We've agreed to the conditions that the staff has suggested. There's a lot of photos of this property over time. It is better than it is now, or was in the past when the complaint was made. He has done some cleanup efforts. Regarding the variance, at the time that he erected the fence in 1989, the county zoning ordinance for I-2 required a 6-foot fence, and it's now a 4-foot fence. So it's not a hardship he created. Legally, he had to put up a 6-foot fence, and that's been on the property since 1989. The property has always only had 60-foot of frontage for the second variance, so there's nothing else we can do with the frontage. If no special use permit is required, it doesn't need there's no frontage requirement at all. That's for the special use permit. So we'd ask your support. We're willing to license the vehicles, license the trailers, have the county come out and inspect. The conditions say they'll be out in 60 days. We're also willing to, do whatever the county requires so that he can continue this. He's an octogenarian. This is where he stores his car parts. They work on the vehicles in another location, and he'd like your support. Are there any questions I can answer?
Thank you.
Thank you very much.
Steve, did you have a comment?
Yeah, normally when something comes up like this, I would be 100% in favor of the property owner saying that the government's screwing them again. And in this case, though, I seen the photos, and there's no effort at any point to make this anything else but a junkyard. And like all these other people that I go out and fight for, like Tammy Wilson and Walter Hartwog, and go on and on, all those people were actually getting injustice from the government. But in this case, I think this guy just operated the way he wanted to, and he had no attempt at keeping it clean. It's a hazard for that area. So I don't see how we can vote for him. And like I said, that's completely the way I normally would not vote. But in this particular case, I'd have to vote to deny it.
Okay, Judy?
Well, I'm going to say something that Steve has said before when he said he agrees with Jackie Kinnear. I just want everyone to know that I agree with Bob Howard. I think that a lot of times situations change over time and the landowner is in the middle of it. I have spoken with our staff, and this gentleman has worked for the last several years in working to comply with things. He didn't want to do it. He got taken to court. He was in court. He was told what he had to do to get in compliance. He's doing that. He's in agreement with that. I think we can't ask for more. I'm a big property rights person. I hate when somebody, especially a municipality, is going to tell somebody in an unincorporated area, this is what you have to do. Really? No, I live in an unincorporated area for the reason that I live there, because I want that and I want less rules and less restrictions upon me. With the pictures that I can see on this, with the slats in there, it's really, you can't really see much on here. So the pictures that I looked at. So I agree with Bob Howard, and I will also be supporting this.
Are there any objectors who'd like to come up to the podium?
She's over there, too.
Judge, up here. State your name and address, please.
Nicole Knapp with the Village of Bolingbrook, Planning and Zoning Administrator, 375 West Briarcliff, Bolingbrook, Illinois. Good morning. It's my understanding that in your package of exhibits you would have been provided with the Village of Bolingbrook's letter of objection, including a formal resolution approved by the Village Board of Trustees, which opposes the applicant's request for the outdoor storage yard. I'm here this morning to expand upon the objection. As you're aware, the subject site is an isolated property within county jurisdiction and is completely surrounded by the Village of Bolingbrook, which is very visible from I-55 and southbound Veterans Parkway. The Village of Bolingbrook is reaching build-out, and the subject site is in the middle of an existing attractive business park area. We ask that you consider that the county codes regarding the fencing and screenings and the use as it relates to outdoor storage are less restrictive than the Village of Bolingbrook. And in the future, when the property is annexed to the Village of Bolingbrook, we would inherit any conditions you apply upon the property, including any variances you granted as well. If I may, I'd like to share an aerial exhibit with you. Approving the special use for an outdoor storage yard impacts the Village of Bolingbrook in such a way that earlier this year we approved an 11-acre development, which is slated to break ground in the next 1 to 2 months and would be located immediately southwest of the subject site at the corner of Veterans and Crossroads Parkway at the hard corner. You can see that imposed over the aerial view. The proposed plan for the development is for a 180,000 square foot Class A office distribution building, and the existence of the subject site as it is today as a junkyard or in the future as a storage yard makes it very difficult to market and lease the property. Additionally, in 2013, the Village of Bolingbrook annexed the 8-acre site that wraps around the subject site directly on the west and south. We rezoned the property I-1 Limited Industrial, which is consistent with the surrounding zoning of the office business parks within the Village of Bolingbrook. The aerial concept plan also depicts the approved development at the southwest corner of Crossroads at the hard corner of Veterans and Crossroads Parkway, but it also depicts a concept of how we believe that developer plans to expand upon the development and add another building over top of what you currently see today as Chicago truck parking, which is outdoor trucks and parking storage. At the Planning and Zoning Commission, the applicant stated he has no intentions of growing the use, that he plans to just keep it on the roughly 1-acre site that's located closest to frontage north of the pipeline. But by virtue of granting the special use permit, there is no condition of approval that keeps him from growing the use to the entire 3-acre site, which is, for your perspective, the size of almost 3 football fields. So unless there's a condition of approval that states what the applicant can store there or how much of the land can be covered, the options are almost endless of what junk can be there. I'd also like to share with you an aerial view that captures a snapshot of the past 21 years.
Do you have copies for me?
Yes, there are extras. As you'll see from the pages of the aerial views that are a snapshot of the 21 years, for the most part, the majority of the storage has not moved since 1998, and the vegetation has actually grown above and beyond and around the storage of the junk. And then lastly, obviously, if you visited the site, you're aware of what I'm going to show you now, but there's digital pictures that I've taken from last week, which again shows how the vegetation has grown around the outdoor storage of of junk. The applicant testified at the Planning and Zoning Commission that he's cleaned up the site quite a bit, and it's purely antiques that are on site. In the Village of Bolingbrook's opinion is that if there was anything of value or salvageable on the site, we can't identify it. In closing, the Village of Bolingbrook believes that the staff recommendation and the accompanying ordinance are contradictory to the applicant's intentions. The applicant's application states that he wishes to store antiques of auto parts in the trailers and antique auto parts on site. And it's in our opinion that if something was an antique or deemed to have any significant value, the antique would be stored in a secure climate-controlled building and not on raw land or in the back of a semi-trailer which is rusted beyond use. The property is nothing more than a junkyard, and I ask you to deny the request you have before you this morning. Thank you.
Thank you. Any questions?
If we were to grant the variances, what's our enforcement policy on that, or do we have one?
I'm sorry,
If we grant the variance?
The variance is just address existing conditions on the property. So the variance for lot frontage addresses the fact that the property is deficient in 20 feet. It's supposed to be 80 feet, it's 60 feet in width. The second variance for fence height would allow for the 6-foot fence to remain within the front yard setback. As far as the use of the property, the use correlates with the special use permit request.
If they were to violate the use of the permit, then?
If the special use permit is denied, we'll have to remove everything from the property.
Mike, what would be allowed in the current use?
In I-2 zoning, there's a multitude of uses that are
No, I'm
permitted.
talking about with this here stuff. What would be,
Everything has to be operable and registered and licensed. So what we'll have to do is for every truck trailer that's out there, he's going to have to get a license plate put on it and register that trailer. For all the vehicles and equipment out there, it has to be shown that it's operable. If it's inoperable, it'll have to be removed from the property.
But that's what he agreed to, right?
He's agreed to those conditions. So staff's perspective is everything's licensed and registered and everything's operable. There are a lot of trailers on the property if you go through that corridor. There are other trucking operations and other warehousing operations. It would be fairly compatible, but he's going to have a lot of work to do to get to that point.
Mr. Howard?
Thank you for the photographs, and it even reinforces my opinion even more. I mean, this is you need to look at this if you haven't looked at it yet. I mean, you're surrounded by truck trailers. All right, there's no residential around there. There's nothing else around there. It's almost like he's being pressured to actually relinquish his property in here. That's the way I feel about this. I mean, this is blatant here. And as far as the truck trailers, and as far as storing antique parts or whatever in there, I mean, I'm a subscriber. Like I said, I collect older cars. And periodically they find these cars in there from someone that owns a Chevy dealer from the past or whatever. They'll find $300,000-$400,000 cars that have been stowed away in these truck trailers. So, but that's not our job as a government official to determine what he has inside those trailers. I mean, basically you're talking about Big Brother at the extreme on this now. You know, and as far as the municipality coming in and saying, well, we don't merely like what you're doing there, so you need to go, or you need to relinquish your property or sell your property. That's wrong, and just flat out wrong. So, you know, that's my personal opinion on this.
I also appreciate the aerial view because it does clarify, just like Bob said, everything around here is truck trailers. This guy has owned this property for a very long time. I'm sure that these existing truck trailers and the use around his property was not this 26, 30, however many years ago. That has changed. So now the government of Bolingbrook is coming in here and developing these parks, and it's decided that this man's property should change because now it isn't feasible for what you'd like. I support the landowner, period.
Thank you.
May I respond?
Okay.
Yes, the applicant is surrounded by truck trailers commonly known as Chicago truck parking, which the landowner voluntarily annexed 2 years ago. And we put a sunset clause on the special use permit so that we didn't have to live with this forever and that it wasn't grandfathered. The other site that's at the corner of Crossroads and Veterans, we've been working since we annexed that property to clean it up. And now we're ecstatic that it's going to be developed with a Class A industrial building. That all being said, he's not compliant today. He's in violation of your ordinance. By granting the special use permit, we're just asking that you consider that you're allowing a use that's not legal now to continue. We're just asking you to consider that. Period. Thank you.
Thank you. Any other objectors? No other comments? We have a motion to approve the special use permit for this case.
Motion.
Motion?
Second.
Second? Roll call, please.
Chairman Weigel,
No.
Robert Howard,
Yes.
Warren Ferry,
No.
Denise Winfrey,
Yes.
Steve Ballage,
No.
and Megan Freitag,
No.
Judy,
Yes.
Four for no and 3 yeses, so it's denied. We go to the county board with a recommendation for denial. Mike?
I would ask the committee to also vote on the 2 variance requests. Again, those were subject to an appeal from the Planning and Zoning Commission.
Okay. Entertain a motion for the variance from 80 feet to 60 feet on the frontage. So moved.
Second.
Second. Roll call, please.
Let's change it.
Tom Weigel,
No.
Steve Ballage,
Yes.
Judy Ogawa,
Yes.
Megan Freitag,
No.
Lauren Stanley Ferry,
No.
Denise Winfrey,
No.
Robert Howard,
Yes.
4 for denial. Motion is denied. A motion for the fence height variance from 4 feet to 6 feet.
Motion.
Motion.
Yep.
Second by Howard.
Yes.
Roll call, please.
Steve Ballage,
Yes.
Robert Howard,
Yes.
Yes.
Megan Freitag,
No.
Judy Ogawa,
Yes.
Robert Howard,
Yes.
Denise Winfrey,
Yes.
and Lauren Stanley Ferry,
No.
Myself.
Chairman Weigel.
No. 3 for denial, so that motion is approved.
Yeah.
Okay, we'll move on to the next discussion. Before we get to that,
Could I suggest that if I just there's citizens here for some of the other matters that follow that agenda item, would you perhaps want to go ahead with those prior to the discussion that I was going to present?
okay. First off, Steve Lazar was going to be here with CMAP. Are they here? Okay, would you like to come up and give us a short presentation?
Well, let me introduce that then. We're going to do that under the director's report. But in any event, we have with us Colin Duzing, who is a long-range planner with our office, and then also Trevor Dick, who's a senior planner with the local technical assistance program with CMAP. Many of you will recall that several years ago now, we received a local technical assistance grant from federal funds that CMAP have received to do the Fairmont plan, and we're now well into implementation of that particular undertaking. We are happy that relatively recently we received approval for a second local technical assistance grant project where we will be doing a plan development somewhat similar to what was done with Fairmont for the Preston Heights area of unincorporated Will County. Trevor is going to give a brief presentation on the scope and approach that we'll be taking to implementing that particular plan in Preston Heights.
Great, thank you very much. Good morning, committee members. Thank you for the opportunity to speak to you. My name is Trevor Dick. I'm a senior planner with CMAP, the official planning agency in Northeastern Illinois. The purpose of my presentation is to just briefly inform you about a project that we're going to be working with you and county staff over the next 10 to 12 months, and to highlight for you our process. So we're at the very beginning phases, so much so the county board still hasn't, or is still in the process of adopting our scope of work and MOU. So this is purely just an informal briefing. Hopefully, my understanding is that'll go before the county board next month. So I just wanted to make sure that you knew about this project. So the project that we're going to be doing is for the Preston Heights and Patterson Road neighborhood area plan. I'm sorry. I have a map here. It's very difficult to see. I apologize. Some feedback. Metal plate in my head. Generally, the study area is bounded along Route 53. The study area is I-80 to the north, Route 52 to the east, Rachel Avenue to the south, and Brandon Road to the west. And it's, as I said, the Preston Heights and Patterson Road areas. I'm going to be working with the staff of about 5 key people at CMAP with specialties in land use, transportation, economic development, water management, etc. And we're going to be working with not just the staff, but all the other CMAP employees that we have, a team of 100 that we can use at our disposal. Probably not the right way to say that, but they'll be on our team as well. And we'll be working very closely with county staff and the elected and appointed officials throughout this project. I have over 20 years of public sector and private sector planning experience, and I've done hundreds of neighborhood and comprehensive plans throughout the country. I'm very familiar with Will County. I live in Will County. I've also, as Kurt mentioned, worked with the county to do the Fairmont Neighborhood Plan, and we're really excited to be back here working free of charge, by the way. Back when I was a consultant, I could never say that, so it feels good to say that for you. Staff submitted an LTA program grant submittal, and they were successful in doing that. We only do 20 projects a year free of charge, so congratulations to staff for the successful submittal. Some of the key things that we'll be looking at in the neighborhood plan that we'll be doing, I've taken a drive with Steve and his staff already, and that was very informative, helped us create the scope of work. Some of the things that we'll be looking at as we do the plan is to try to improve pedestrian and bicycle circulation and access throughout the area, connecting the neighborhoods to the school, and also trying to get across Road 53 safely. We'll be looking at that. We'll look at future land use for all unincorporated areas in this study area. What do we want the future land use to be in the next 10, 15, 20 years? We're not going to be doing zoning, but what is it from a future vision point of view? What do we want to see happen in this area? We're going to look at some strategies to try to improve the image, the character of the area, try and improve the look of the area, trying to make people feel proud to live in these areas. We want to make sure that we strengthen that and encourage that. We're going to look at ways to improve public transportation in the area. And lastly, some economic development opportunities. We're going to look at key parcels, especially along Route 53, to see what type of businesses, employment, or shopping things that we can add to that area to help support those neighborhoods. Our planning process is expected to last 10 or 12 months. We'll be working very closely with residents in the county to create the plan. We'll be working with the public. The public participation will be the cornerstone of this process. We want to make sure that the neighbors, the businesses, the churches, the agencies in those areas know that this is their plan. It's not CMAP's plan. It's not even really the county's plan. It's the residents' plan for what they want to see happen in the area. And frankly, it'll be up to them primarily to keep moving the plan forward. For the Fairmont Neighborhood Plan, for example, an excellent case where this is what's happened. They've taken the plan and they've run with it. And so we want to make sure we do the same thing in this area. We're going to form a steering committee that's going to help us be our guiding group throughout the process. We're working with county staff to identify who will be on that steering committee. Ideally, it would be a good mix of residents, business owners, religious institutions, etc. And they're going to be our guiding team throughout the process. Our scope of work, it's probably about 15 or 20 steps, but really there's 3 things we're going to be doing. The first big step is to identify existing conditions. We're going to make sure we drive every street in this neighborhood, take pictures, identify existing land use, talk to as many residents as businesses as we can to answer the question, what is the existing conditions in this neighborhood right now? Once we have that existing conditions under full understanding, we'll move into the second phase, which for me is the most exciting, that's the visioning. That's where we'll work with the residents and the steering committee to come up with, okay, where do you want this neighborhood to be in the next 10, 15, 20 years? The one thing I'll do at the meeting is I always like to say there's a fine line between visioning and hallucinating, but we'll still let people dream big, and our expertise will be able to provide especially economic development points of view to make sure that they will get a sense for what can happen in the future. And the third and final step is implementation. We want to make sure that we come up with priorities, strategies, potential partners, or funding sources to make sure we can get things to happen. And I think that's actually one of the most important steps. So that is the end of my brief discussion this morning. I want to tell you how thrilled we are to be back in Will County doing work with you and those neighborhoods. And we're thrilled. And if you have any more questions or any questions this time, I'd be happy to answer them at this time.
Yeah, as far for your visioning section,
Yes.
you will have different meetings, I know that. And will they be held at different times during the day? Will they be held just during the work hours, or will they be in the evening as well?
Well, that'll be something we'll work with staff and the steering committee to identify. My goal is always to try and get as many people involved in the process as well. So we may have meetings during the day with the steering committee. Ideally, we'll have public meetings in the evening. My experience is that evening meetings is where you can get the most participation. We'll also have an online website that'll be linked to the Will County website. So if people can't come to a meeting, they can follow the progress online, look at upcoming meeting schedules, etc. So I guess to answer your question, steering committee member, well, for Fairmont, I'm thinking we have the steering committee meetings in the afternoon, and those evenings we would have the big public meetings.
Good, because a lot of times governmental agencies, groups like yours have public hearings during the day.
Yes.
And the average person then has to take a day off of work to go to that public hearing. And I mean, I've gone to CMAP hearings, they're during the day. I've gone to IDOT hearings, they're during the day.
Right.
It makes it very difficult for somebody, especially when there's multiple meetings you want to attend, a lot of the meetings. In this situation, a lot of people might want to attend. So I'm glad to hear that you would be doing public hearings, public meetings during the evening.
Definitely, yes, thank you.
Thanks, Trevor. And to your point, it's very well taken, and I've had the opportunity to work with Trevor before on the Fairmont Committee. And what they typically do is use a focal point in the neighborhood and then do the evening meeting as well. So that worked out very good. We used Shiloh Church to do the community meetings in the evenings for that area, for that project, and it worked out great. That's good. So we're expecting to do the same thing again this time. And tied to that, you all may know that the Park District has passed a referendum, and so Knoll Park, which is the major green space in that area, is going to be upgraded. And we're doing evening meetings for that, which will tie into the CMAP project.
Good, good, good.
Good, yeah,
That's great.
thank you.
Thank you very much.
Thank you.
Appreciate your work effort on this.
Thank you.
Back to our agenda. Waiver of ordinance for Molino subdivision. Mike?
Thank you, Chairman Weigel. This subdivision waiver is waiving a provision within the subdivision ordinance that requires newly created parcels to contain frontage on a public road. The parcel being created is to be improved with a wireless telecommunications facility, also known as a cell tower. The parcel will be accessed via an easement. It will grant workers the right to access the cell tower in this area.
This is in Wilton Township.
This is in Wilton Township, and it relates to the next zoning case we'll consider, which is case 6219-V. The wireless telecommunication facility is at least being partially funded by the Department of Agriculture under their Broadband Initiatives Program. The intent of that program is to provide wireless internet access to rural areas of the country. So staff is recommending approval of a subdivision waiver.
Any questions by committee? We have a motion to approve?
Motion.
Motion. Second. All in favor say aye.
Aye.
Any opposed? Motion carried.
we could we skip right to the zoning case?
Okay.
That
6219B.
That variance relates to the cell tower being constructed. State statute limits cell towers to 200 feet in height. In order to provide wireless internet coverage to the entire area, they have to go higher. So they're requesting a variance up to 254 feet in height. The tower is being constructed in southwest Wilton Township, which is a very rural area and will not impact any surrounding properties. Staff recommends approval.
Okay. Any comments? Judy?
Yeah, I live with Bob out in Eastern Will County. We're the only two people out there, by the way. And I know that we've had a really difficult time getting high-speed internet. You might get it onto this company for a while, and then trees in the area grow up, and then their cell towers aren't high enough. So I think the cell tower in rural area is an issue where they do have to be above the maximum allowed, because the dynamics change, and they can change over time. I mean, we might find that they have to get a little bit higher than 254 feet, I don't know, or put up more, something like that. So I totally understand the need to increase that height.
We have a motion to approve. So moved. Motion.
Second.
Second. All in favor say aye.
Aye.
Any opposed? Motion carries. Item 3, Mike, did we already do that? Or?
We already did that.
Okay. Item 4, text amendments. David?
Yes, I will be brief. Just the first thing I want to advise you is that the public hearing for the outdoor lighting provision will be June 2nd. That was not held this month due to timing with publication requirements, so that will be on June 2nd. The second thing I want to update you on is that with regard to the more larger list of text amendments, I'm going to be initiating, or actually have initiated some consultation with the clerk's office regarding the online code with American Legal. And I've been in the process of trying to migrate from traditionally having Microsoft Word or PDF copies and maintaining that, as well as having the online code maintained by the clerk's office, which is the official copy of the ordinance, just going strictly to the American Legal. And in doing so, with a lot of text changes, I need to make sure that I'm being consistent and 100% accurate with their code. So I'll be talking with the clerk's office as well as with the American Legal Company to make sure we do this correctly. And then I will also be initiating some discussions with the chairman to possibly have meetings outside of the regular scheduled meeting to focus upon the zoning ordinance, because there has been an increased zoning caseload. We do not want to be distracted by that. We want to focus on the text amendments.
Okay. Thank you. Any questions? Okay. Kurt, we'll go back to the building pre-inspection. Give us a little background on the situation.
Do we want to go through this today without the Illinois regulars today? I mean,
I discussed that with the chairman. Is at your discretion?
yeah, I would assume for the sake of time that we'll just push it off to where, basically, we'll hear your part of it, then a month later we'll have to sit and listen to this again. So I mean, let's just.
My thought is that we would review it and look at the recommendations, and we could forward those to the realtors for their review to see if they agree with them or not agree with them. So they have something to respond to.
Right. And we can see what's going on and
That makes sense.
no decision.
I thought we were just going to listen.
Steve?
Yeah, it has to do with pre-inspections and all the other inspections. I mean, it seems to me like we're trying to make building codes stricter and stricter and stricter, and we don't have to do that. We can choose not to do that. And I'm a little bit frustrated, you know, it's this pre-inspection thing, it's a violation of the Fourth Amendment. It shouldn't be brought up here, because when someone calls you up and says, come inspect my house, that's one thing. But when you go out there to inspect because they applied for a permit, well, that permit, you should be allowed only to inspect what the permit was for and nothing else. And I think we're going way, way out of over bounds on this stuff. And we need to reel ourselves back, make the regulations less stringent, and let the people have a life. We're not supposed to be a nanny state, and that's where we're going. And I don't like any of these ordinances. Pre-inspection means that we're going to go in and tell them, well, the code changed, so now you're going to have to do something different. Well, their plan was to do, they might have already built something, and it doesn't meet the current code, but it met the current code before. You go in a house and you saw mold, well, yes, dangerous. Well, if you didn't see it, the people, they have to clean it up to live there. So you don't have to write them up. And if they didn't clean it up, that's their problem, it's their house. So I'm really, I don't like the idea that when we talked about in legislative, that we bring up things that we really shouldn't be bringing up. This pre-inspection thing has no business here. We shouldn't be doing it, period.
Thank you for your comments. Kurt, would you like to proceed?
The committee will recall that in the March meeting of the Land Use Committee, matters pertaining to the utilization of preliminary inspections came up. Representatives of the Three Rivers Realtors Association presented concerns regarding that particular practice. It was discussed within the committee at that point in time to have staff develop various ideas and concepts related to either a modification of that element in the code or possibly even its total elimination. So at the meeting in April, your last meeting in April, staff was prepared to present a report based upon the requests that have been made by the committee to outline various alternatives to address the concerns that have been raised by the Realtors Association. On that particular occasion, for a variety of reasons, the representative of the Realtors Association was not in attendance, so you recall that the matter was tabled to today. So what brings us to the situation today is to give you staff's response to your request to, again, come up with either alternatives to modifying the existing code provision on this topic, or perhaps even eliminating it altogether. Now, to do that, it's my view that it would be necessary to give a little bit of background and context to what is this topic, what is the legal authorization for the practice, and so that once we have a better understanding of what it is and how it is utilized, and perhaps what the benefits are, then we will be presenting some suggested alternatives that, again, are meant to address the committee's concern for possibly adopting changes to the existing code to address some of the concerns that have been raised by our friends and colleagues in the real estate industry. So with that in view, let's go on to the next.
I have a question before you went through.
Mr. Chairman, is this how you want to do it?
No, let him go ahead, Steve, through his presentation. Then at the end, you can ask more questions.
Okay. So, the term preliminary inspection is a term that is derived from the 2012 Residential Code, the International Code Council, which the Will County Board has adopted when they adopted their revisions to the building code, which became effective in June 1 of last year. For those of you that are not familiar with how this process works, not just Will County, but every jurisdiction, just about every jurisdiction who has a building code, passes an ordinance, but in that ordinance, it's really pretty narrow. And it basically says, we're adopting by ordinance certain international codes. Now, do you have to adopt those codes at all? Certainly not. And if you do adopt them, certainly do you have the opportunity to make decisions about, well, there's one element or many elements of that model international code that we just don't feel are appropriate for our jurisdiction, that just don't fit our circumstances. So then you pass a local amendment that says that particular part of the international code is out as far as our particular jurisdiction. You'll certainly recall that, and some of your colleagues served on this particular task force, that over an 18-month period, going back to over almost 3 years ago, hard to believe, we did a very in-depth analysis of the building code and its provisions, trying to update and adopt the 2012 provisions. And at that time, there was an exhaustive review. Did it look at every dot, every twiddle? Probably not. It was almost an impossible task to do that. But I know that Mr. Balish, Mr. Weigel, and the others that served on that committee gave it their honest best to analyze in depth what is it that we would be adopting, or recommending to the board to adopt, not only with respect to the ordinance itself, but more particularly the provisions of the code, and recommending any local amendments that they felt were necessary to meet Will County conditions. Just to remind you, one of the most prominent examples of that was the matter related to residential sprinklering. The particular code that was being considered at that time, if it had been adopted in its entirety, would have included sprinklering, but the board decided that's a good example of a local amendment that we want to make. So that's just to give you a little bit of background. Okay, within the code that was adopted, the 2012 residential code, there is a provision for what is called a preliminary inspection. And essentially what that involves is an initial examination of a building, structure, or site conducted prior to the issuance of a building permit. Now, it just simply has that element. I mean, I can read to you what it says. This is in section 105.9, preliminary inspection. Before issuing a permit, the building official is authorized to examine or cause to be examined building structures and sites for which an application has been filed. So, the first thing I want to get across to you is that there has been the suggestion in various emails, public discussion of various types, that the activity of conducting or requesting would be a more appropriate way to put it, because all inspections are requests for which there has to be consent. That somehow or another, even with that consent, that the performance of a preliminary inspection is somehow something that is not currently legally authorized under the Will County Code. I ask you to not just listen to me, but to listen to legal counsel as to whether that is correct. It is most assuredly currently legally authorized. Now the question that you'll need to ask is, well, so what? I mean, there's a lot of things in this life that are legally authorized that upon further reflection, we don't feel are serving any worthwhile public purpose, in which case they're removed. But I think it's important to have an honest discussion about this, that we make sure that we recognize that the preliminary inspections is currently authorized by action of the county board in their adoption in just last year, of the 2012 residential code standards. Okay, now what are some of the purposes and benefits of doing a preliminary inspection? I will absolutely grant you that if you listen to that language, it is a much broader grant of discretionary authority to the department than this board has typically granted. It doesn't limit the instances within which a preliminary inspection could occur. It does leave a considerable amount of discretionary authority to the building official to determine if and when such a preliminary inspection will be conducted. It does not say that a preliminary inspection will be conducted in all instances. It says that it will be done when in the determination of the building official it is necessary to do so in order to fulfill the fundamental purposes of the code, which are described in the code itself, which is to protect the public health and safety. So, just that's a preview of coming attractions. One of the considerations that you'll see in the alternatives is the committee and then the board ultimately, if they decide to preserve preliminary inspections at all, you may choose to become more specific about those instances, and only those instances, within which a preliminary inspection could be performed. But with that in view, how has the department been deciding to employ preliminary inspections, and what do we perceive to be the purpose and benefits of preliminary inspection? As representatives from Will County, you are well aware that Will County has been, unfortunately, This is not one of those things for which we like to be distinguished. But unfortunately, Will County has been something at the epicenter of the foreclosure crisis over the past 6 years. We still remain, in terms of overall ranking within the state, the 7th highest incidence of foreclosures in the entire state. 1 in 383 properties in Will County is currently in foreclosure. Now, and actually that has gone up to March 15th, because in December 12th it was 1 in 268. Or I should say it's gone down. The incidence has gone down, which is important to recognize that things are getting better, but the problem has not gone away. Well, what's the relevance of that? Just common sense, as well as many press reports and perhaps your own personal experience, would indicate to you, although it's not a universal condition, the fact that a property is foreclosed suggests that many times it will be abandoned, sometimes for a considerable period of time. I'm sure you've all read all sorts of press reports about situations where an abandoned house becomes a target for vandalism. Copper pipes are removed, electrical systems are removed, heaters are removed, fixtures in the bathroom are removed. And a house that's abandoned is prone to get damage to the roof, which brings about water infiltration, which can bring about structural damage to the property or can lead to the formation of mildew and mold, which can be just quite injurious to health of individuals. So that is one reason why we have felt that in the case of a foreclosed property, which we determine, as we always do, what the ownership of a property is at the start of the application process, if the county's tax records indicate that this is a bank-owned property or owned by Fannie Mae, quasi-governmental organization, which holds, I think it's close to 2/3 of the defaulted mortgages in the United States, if they are the current holder of the deed for the property, we know it's in foreclosure, and we have felt in those instances that in order to fulfill the fundamental goals of the code, which is to serve public health and safety, we need to see that if a roof permit comes in, that the structure is sufficient to support a roof, if there's been water infiltration and other items which are making the house hazardous to human occupation. So with another area that doesn't have to do with foreclosures that I think we need to know is a use for preliminary inspections is that insurance companies, as well as individuals who have insurance policies on their property, which is just about all of us, when they experience a catastrophic loss, a fire, a flood, some other type of event of that nature that brings about substantial damage to their property and they go to file a claim, it's quite often the case that the insurance company will request of that policyholder that they contact their local government and have them come out and conduct a preliminary inspection to establish a baseline of what is the extent of the damage and what extent of work will be necessary in order to bring that property back into code compliance. I have correspondence that I could share with you from a number of insurance brokers who talk about how essential that practice is to assuring the rapid, complete, and thorough processing of insurance claims to their folks. So as I mentioned to you, if we were to totally eliminate authorization for preliminary inspections, it might have the unintended consequence of limiting our ability to be responsive to the request of a property owner and their insurance company to do this type of baseline assessment of damage to their property. Another area where a preliminary inspection is used is in those cases, I know it's hard to believe, but quite often people will undertake building activities without obtaining a permit. And sometimes that comes to our attention and sometimes it doesn't. But when it does come to our attention through a bona fide complaint, and we go out and see some building activity has occurred, we then have to have a situation where floors are in, walls are up, all sorts of things are done, but no way of ascertaining whether it had been done according to the Will County Code. So that's a situation where the person is going to be getting kind of an ex post facto permit, might be a way to express it, in order to have them understand and establish what is the scope of that permit. we need to go in and do a preliminary inspection, once again, to establish a baseline. So the reason I mention those is I don't want to put words in the mouth of the representative from the real estate group. His concern was clearly largely focused on foreclosed properties. However, but I think it's important for you to know, as you're considering amendments to the code, that the preliminary inspection that the code currently allows for is utilized not only in foreclosure situations, but the insurance claim processing situation I mentioned, as well as in situations where there was building without a code. What I'd like to do, without a permit I should say, what I'd like to do now is just briefly go through my understanding. Once again, not trying to put words in the person's mouth, but my understanding, listening and having discussions with the realtors group on several occasions, what their concerns were, and then compare and contrast that with what we believe to be the facts of the situation. First concern that you can see is the preliminary inspections are currently conducted without legal authority granted by the county board. We alluded to this earlier. That is a concern that's been expressed. I believe the facts are that, as I pointed out to you, section R105.9 of the adopted code indicates that there is clearly a provision for preliminary inspections. And that was, as I mentioned, a part of the 2012 International Residential Code that was adopted in the Will County Building Ordinance by the county board, which became effective June 1 of last year. So you can draw your own conclusions, but I think after consultation with our attorney, who is your attorney, it suggests that there is solid, sound, clear legal authorization for the conduct of preliminary inspections. The next concern that has been expressed is that, well, whether it's authorized or not, such preliminary inspections somehow inherently violate provisions of the Fourth Amendment of the U.S. Constitution. A very serious concern. What do we believe to be the facts? We believe that all inspections, whether it's a preliminary inspection or an inspection done, so-called final inspection prior to the issuance of an occupancy permit, always needs to be respectful of the property owner's Fourth Amendment rights. And how do you demonstrate that respect? You ask for consent for any inspection. I'm not an attorney, there's attorneys among you, you have legal counsel. But my fundamental understanding of how do you show compliance with the Fourth Amendment is that unless you have a warrant, or unless you have received the consent of the property owner, you do not go into the property. Here's the situation. In those instances where we ask for a preliminary inspection, just like we do on all inspections, authorization from the property owner or the property owner's authorized representative is obtained prior to that preliminary or any other form of inspection occurring. That being said, I don't believe that there's any violation of the Fourth Amendment in how this matter is undertaken. Next concern that has been expressed, and this is an important one because I know this to be of serious concern to the realtors. Their concern is that the initiation of a preliminary inspection is triggered by the current or proposed for sale status of the property. In addition, the successful completion of the preliminary inspection is a required or mandated requirement for the transfer of property to a new owner. Where does this concern arise from? Our friends and colleagues in Romeoville adopted a practice in response to the very intensive foreclosure situation that they've been experiencing. An approach which is their approach. It's not our approach, it's their approach. Within their jurisdiction, if you are a property that's in foreclosure, you are required by local ordinance to register that property at City Hall to let them know that that's the status of the house. Then, prior to the real estate transfer occurring, you have to request from the City Hall that people come out from the inspection department and do a top-to-bottom inspection of the house for its adherence to all local codes. and then you are given a stamp and a seal, which when you go to pay your real estate transfer tax and to record the property, you have to demonstrate that that inspection has occurred. Now clearly, in that instance, by design, the activity, the preliminary inspection, is triggered by the sales transaction, the for sale status of the house. Well, what is the case with us? The concern is that we're doing the same thing. Here are the facts. The preliminary inspections performed by the Land Use Department are not in any way whatsoever initiated by the for sale status of the property. Rather, the only condition which may trigger a preliminary inspection is the property owner's voluntary application to receive a permit. And completion of that preliminary inspection is in no way a mandated requirement or precondition for the sale or transfer of the property's ownership. Whatever results come about as a result of that preliminary inspection has no bearing on whether that individual can sell that house in the sense of whether it's legally required. So, you will often hear our friends and colleagues from the real estate industry be referring to this whole subject matter as a pre-sale inspection because of their concern that it's triggered by the sale. Although we've had many discussions with them on this point, I can't seem to get it across quite yet that the thing that's triggering the inspection, like all other building permits in unincorporated Will County, is the fact that certain work, certain construction activity, certain remodeling activity is proposed to be undertaken that is of a scope and of a type that the code says requires a permit. It has absolutely nothing to do with the sales status of the house, whether that house is scheduled for sale in a month, a week, 2 years from now. So that's that particular concern. Finally, the other major concern that's expressed is that even if a program of preliminary inspections that are targeted by a property's for sale status does not currently exist, there seems to be a belief, and I'm drawing this from email traffic from the Realtors Association, is that the county is somehow considering adoption of such a program. Now here are the facts, and you know this better than anybody else. The county is not currently conducting a PI program that's triggered by the property's for sale status, and certainly, to the very best of my knowledge and my understanding of the attitudes and beliefs and policy preferences of this committee and of the board, they're not considering doing that, either now or at any point in the future. So I think that's one concern that we can put some relief in the mind of our friends in the real estate industry, that no one is considering adopting a Romeoville-style program at this point, nor are we currently conducting one. So we'll just put up the screen, and I won't go through it again, but just a summary, once again, of what I believe are the 4 major concerns that have been expressed by the real estate industry on this topic, and then contrasting that with what we believe to be the facts and the reality of the situation. I won't go through that again. You can use that for your future reference. Now, to really what brought us here. Given the concerns of our friends in the real estate industry, we were asked by the committee to come up with various alternatives that might be an amendment to the existing code or some other type of change of practice that could address their concerns. Well, let's run through those. One possibility in broad terms is you could adopt a local amendment to the building code that would completely remove that section which I cited for you on the topic of preliminary inspections. You could just do a local amendment just like we do on sprinklering. It says, the International Code called for it, but we don't want it in Will County. You'll need to consider the pros and cons of that approach, but you certainly could do it. One of the cons I pointed out to you was that by eliminating that provision in its entirety, you would make it difficult, in fact impossible, for the department to undertake such a preliminary inspection for those insurance claim processing issues or for those instances where we had build without permit. But you do have that option available to you. A second one would be adopt an amendment to the current Will County Building Ordinance, which would limit the application of R105.9, which is the provision related to preliminary inspections, that would limit it to certain specific circumstances. Now, I've enumerated them there. You could do A, B, and C. You could do B and C. You could just do B. You could do whatever specification you chose to say, okay, you can do a preliminary inspection, but you can only do it in these particular circumstances. That would be another option that you'd have available to you. A third option, which I will be candid to say to you, I have not yet had vetted by the state's attorney's office as to its legal effect or even its feasibility. But another potential opportunity for exploration would be to adopt an amendment to the current Will County Building Ordinance, which would provide authorization for a property owner to sign a waiver that would release the county from any liability in instances where the county believes a preliminary inspection is necessary and appropriate, but the property owner would prefer to forego the PI. So this is a situation where, in our professional judgment, we really feel it would be appropriate for some of the reasons that I've cited to you. We would present that to the property owner. They would choose not to give voluntary consent for such an inspection, but in fact would be willing to sign a waiver to say that we're relieved of any future liability arising from our failure to have conducted such an inspection. Another option, and none of these are mutually exclusive. A fourth one, which is an option, but perhaps an option without a difference, would be to simply retain the current language of the Will County Building Ordinance on this particular matter. So those are the four broad categories of options. Certainly with creativity, I'm sure we could come up with more and refine some more. But just to conclude by what is the staff's recommendation, we really believe that, in all sincerity, that option 4 is recommended. It offers the best and most reliable means for achieving the ordinance's fundamental goal of safeguarding the public's health and general welfare while promoting the safety of firefighters and emergency responders. However, elements of option 2 and option 3 might represent a reasonable accommodation of the various expressed concerns from the real estate groups while maintaining access to the basic benefits and purposes of preliminary inspections. So in other words, although as staff we believe the situation as it currently exists is the best remedy, however, we would be willing to acknowledge that adoption of aspects of option 2 and option 3 might be a way to reasonably accommodate some of the concerns of the real estate industry without losing the best facets of the current language.
Okay, any questions by committee? Steve?
Yeah, first off, I was on the committee that Kurt referred to, but we never went into the individual codes. Every time I brought it up, we put it off. The only thing we really talked about was sprinklers. And when I brought up other items, we didn't talk about it. And this would be one of the items that didn't come up at all during that process, but it probably should have. When we're talking about the Fourth Amendment, I'm glad Kurt said we get permission before every time they go there. So this goes along with adhering to the Fourth Amendment. But I think where the problem comes in is when somebody calls up and says, would you please come here and inspect my house because I'm going to put a door in, and let me know what kind of wood I have to use and what kind of door I have to get because of the energy code, which, by the way, is something we should have opted out on, but we didn't. I brought that up also, you remember. But anyway, and when you go there to inspect for the door, that's all that should be inspected, nothing else. So once you leave looking at the door and look at something else, now you're violating the Fourth Amendment again because you didn't give permission to look at anything else but the door. So, you know, that's kind of where I stand on it. You know, now if we're going to follow something like that where you go out and inspect for only what was called for, I got no problem with it. I think that's perfectly fine. If somebody asks you to inspect for a door, it's good. But I don't want the rest of the house inspected.
Right. I'm so glad you brought that up, Mr. Balish, because that is the other aspect of the Fourth Amendment discussion that comes up around this issue. It's not just the fundamental question of did you get consent to go onto the property, but while you're on the property, did you waver off the path? Did you go into areas that were not a part of that informed consent, which is that's the essence of what you're asking about. And this is an area which, again, I encourage you to speak counsel from our learned attorney, but I believe fundamentally the issue here is this. Let me give you an example. And you could come up with an infinite number of permutations, and that's what makes this whole thing so difficult to talk about. But let's say that the request you got is, hey, land use department, I want to put in a new water heater. I want to put in a new water heater, got to get a permit for that. Okay, well that's kind of a plumbing problem, might have an electrical dimension to it, and it's probably down in the basement. Okay, well, the guy's giving you consent to come to his house. Well, you're walking down the steps, and you're not looking for it, but here's a wire hanging down that appears to be sparking. Now, I'm giving an extreme example to illustrate a point. What I am told and instructed by our legal counsel is that if the violation is in plain sight, it is appropriate and in fact is necessary that you cite it. Now that in and of itself, clearly, or in a common sense way, has little or nothing to do with the water heater. But if you're walking along and you see it, you've got to cite it. Now that's where these definitional terms come into play. By contrast, you're going down to the basement to look at the water heater. Yeah, you see that dangling wire, but then you go over and, hey, let's look in this cabinet. You open it up. Let's go over here and tear a hole in the wallboard and look at the pipes in there. If that were to go to judicial review, I think those kinds of things would be clearly found to be a violation of the Fourth Amendment rights of the individual. But those situations where it was in plain sight as the individual conducted the inspection for which they had been given consent would not be regarded, I'm acting like a lawyer and I'm not, but would not be regarded by the courts as a violation of the Fourth Amendment. Once again, I'd really encourage you to perhaps have my response amplified by our state's attorney.
Sometimes, you know, the state's attorney,
Just for the sake of looking at this one point of a taxpayer and looking at what this is costing us to have this discussion here right now, taking our staff away from their duties, why don't we just, and Steve, if you want to talk to Kurt after me.
I mean, I just don't like a lot of this stuff here because it is unconstitutional.
We've got 9 people out in the audience that are employees of the taxpayers. So
That's fine.
Yeah, let's move forward here.
Any other comments? I think, Kurt, you should forward this to the realtors and ask for the comments on it, and then we'll proceed from there. Okay?
Will do.
Thank you. I have no comments. Members, any comments? Committee members? Director, any additional comments?
Done quite enough.
Okay, motion to adjourn. So moved. Second. All in favor, say aye.